Turning now to the big Supreme Court decision today, I want to take a moment to briefly have some straight talk about the court ending affirmative action in college admissions, essentially banning colleges from using race as a factor as to whether a student gets in. The court voting 6-3 along ideological lines, which of course means the political extremes are furiously camping out in their respective corners and pushing polarizing narratives about what all this means. The left saying the sky is falling, this is all just more evidence, they say, of an activist conservative majority in the Supreme Court, which in their eyes favors political ideology over the law. And of course, the right claiming the decision was long overdue, the toppling of a racist system, the affirmation of American values, pulling yourself up by your bootstraps without unfair advantage or toxic racial quotas. And yet, I believe that both sides might be partially right in this case. There is a moderate middle ground here, and I don't know that anyone else wants to take it. So on one hand, maybe we can acknowledge that this is going to definitely lead to fewer people of color at the most elite schools, and the history of discrimination in this country still has a serious impact today. And on the other hand, maybe the legal ground on which this decision is based is solid. Justice John Roberts wrote in his majority opinion, eliminating racial discrimination means eliminating all of it. He goes on to say the Harvard and UNC admissions programs cannot be reconciled with the guarantees of the Equal Protection Clause. Both programs lack sufficiently focused and measurable objectives warranting the use of race. Unavoidably employing race in a negative manner involve racial stereotyping and lack meaningful endpoints. He said, we have never permitted admissions programs to work in that way, and we will not do so today. Now, in her dissent, liberal Justice Sonia Sotomayor writing, the devastating impact of this decision cannot be overstated. And, quote, the court cements a superficial rule of colorblindness as a constitutional principle in an endemically segregated society where race has always mattered and continues to matter. So let me say what few are willing to say. Maybe both Roberts and Sotomayor are sort of right. While it's true that for more than 4 decades, the Supreme Court upheld affirmative action in some form, and the court did not have to hear this case. Remember, though, that Sandra Day O'Connor famously concluded in her decisive vote upholding affirmative action in 2003 that while its use in college admissions was justified, it was not intended to last forever. She said, quote, we expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today. That was 20 years ago. Now, of course, she may not have predicted that the media in this country would grow so polarized to the point that any sense of nuance is now lost on either side of the political aisle. Let's start with the left. They're beside themselves.
That's what bothers me about this rolling back. And also what bothers me also is that what's next? Gay marriage?
This is actually a day where we saw the triumph of the kind of right-wing, anti-black politics that people like Donald Trump have fomented.
Is this a rogue court?
This is not a normal court.
And President Biden went on in an interview today to talk about the court's legitimacy. Meanwhile, the right refusing to acknowledge that this ruling will have real-world measurable consequences that have already been borne out by data in a country still feeling the impact of decades of discrimination and oppression.
This ruling will have a powerful effect on minimizing wokeness throughout this country.
One of the most disastrous and failed policy experiments of the last century.
You can't fight discrimination with discrimination.
Look, there are 9 states that currently do not allow affirmative action already. And it's clear in those states that the number of students of color has gone down significantly. So the other workarounds that you might hear people talk about, like colleges now taking zip codes and economic status into greater consideration, simply doesn't make up for affirmative action. That's true. But it doesn't mean that the legal analysis is wrong. Bottom line, maybe the majority is right, that affirmative action had to end at some point, since as a matter of law, affirmative action is incompatible with the Equal Protection Clause, and that the left is right, as a matter of policy, that inevitably this is going to lead to fewer people of color being admitted to top schools, and that after hundreds of years of discrimination, maybe it's a little bit too soon. Both sides have fair points here, But by claiming this was an easy case, that the issues surrounding affirmative action are literally black and white and leave no room for nuance or middle ground, which both the far left and far right in particular appear to be doing, that's simply not true. This was a hard case. It was a close case, as evidenced by the fact that the court has been slowly moving towards this point for over 40 years. Thank you for watching. Go to newsnationnow.com to find News Nation on your cable provider. And don't forget to click the red subscribe button below to get more of News Nation's fact-driven, unbiased coverage.